Hello, everyone. Thank you for joining our webinar today, Me Too 1 Year Later. We're going to hold for about 2 minutes just to make sure that everyone has had enough time to sign on using the system. And after that point, then we will get started. Thank you. Okay, hello everybody. Thank you so much for joining us for this webinar on principles and legislative priorities for eliminating workplace harassment. I'm Andrea Johnson and I'm Senior Counsel for State Policy at the National Women's Law Center. And I want to start by thanking our co-hosts for this webinar, the ACLU, the Leadership Conference for Civil and Human Rights, and the AFL-CIO. Quickly, for those of you who aren't familiar with the National Women's Law Center, we have been working for over 45 years to champion laws and policies that help women and girls achieve their potential throughout their lives, at school, at home, and at work. And as Senior Counsel for State Policy, I get to work with many of you, state advocates and elected officials across the country, to provide drafting assistance on bills, talking points, state-specific data, and legal research to really help advance policies that improve women's and girls' and families' economic security. And as many of you all know too well, this last year has been an intense whirlwind with the Me Too movement taking off in October of last year, not long before state legislative sessions were set to convene in many states. And we've really seen an unprecedented energy to make change in response to the Me Too movement, from the grassroots level and up to elected officials, and also a lot of political will to make this change. So federal, state, and local elected officials from all across the country have been reaching out to many of our organizations about what policies are most important to meaningfully respond to the Me Too movement and make real change. And really, there are so many things that need to change because, as the outpouring of Me Too stories has demonstrated, the laws and systems designed to address harassment have been inadequate to provide justice and prevent harassment. So it's sometimes hard to know where to start. So to help guide this energy and political will towards policy reforms that will do the most good, national and state civil rights, women's rights, and worker justice organizations came together to develop a set of principles and legislative priorities for enacting meaningful and substantial workplace reforms. Many of your organizations might have been involved or signed on to this document. And now, the coalition document, which I got the first page of it pulled up on the PowerPoint, it's designed as a call to action to Congress, but the principles and broad priorities around transparency and covering all workers, making sure all workers are protected, and access to justice and prevention, the principles and those priorities that it sets out are largely applicable to reforms being led by state and local lawmakers as well. Those specific policies will obviously vary state to state. So we wanted to use this webinar to share this coalition document with state leaders and translate some of the legislative priorities for the state lawmaking process where it differs. Now, around the same time that this principles document came out, nearly 300 organizations signed on to a letter published in the New York Times challenging 20 states by 2020 to pass laws strengthening legal protections against sexual harassment and violence. So we hope this coalition document can be a helpful resource for fulfilling that exciting challenge. And given that 2020 isn't that far away, it's really quite soon, we wouldn't be using our time wisely if we just talked about the reforms that we need and didn't talk about what it is we need to do to get them. So we also want to use this webinar to hear directly from state advocates about coalitions and messaging and organizing strategies that have been effective in strengthening sexual harassment protections. So I'm gonna give a brief overview of the overarching principles identified in the coalition document. We'll then hear from Jillian Thomas at the ACLU, who will give an overview of the legislative priorities. And then we'll hear from advocates in the states who are working to advance some of these priorities, including Chris Kaiser from the Texas Association Against Sexual Assault, and Alejandro Valles from the SEIU United Service Workers West, and a member of the Yabasa Coalition, who will talk about organizing strategies for really putting these principles and priorities into action. And then at the end, we've left some time for Q&A, and we really want to hear from other states represented in the audience about things that you have been working on or plan to be working on around workplace harassment. But first, I want to turn it over quickly to our coalition partner, June Zeitlin, with the Leadership Conference for Civil and Human Rights to make a quick remark.
Thank you, Andrea, and hello to everybody. I just wanted to thank Andrea and the Law Center for organizing this and giving those of us who work primarily at the national level an opportunity to have some exchange with those of you who work at the state level. I just want to say a word about the Leadership Conference on Civil and Human Rights, since you may not be that familiar with our work, but we were founded in the late 1950s, kind of the same time as civil rights movement became very active, in order to shape federal policies and legislation to advance civil rights. And as the definition of civil rights became broader, our organization became broader, and now we're a coalition of over 200, mostly national organizations. So I give you that background because I think that shapes, to some extent, what we were trying to do in this principles document. And working closely with the Law Center and the ACLU and labor unions and other organizations that advance workers' rights, we decided that we needed to do something proactive. I'm sure at the state level you experienced the same thing that we were experiencing nationally. Once the Me Too movement went viral, many legislators wanted to know, well, what should they do? Or they introduced a bill on a specific topic and wanted a response. And we felt like we were spending all of our time reading their bills and responding to their proposals, as opposed to having a more comprehensive, proactive vision. And that's really what we tried to do here. And so working with about 30 organizations that represented the diversity of the Leadership Conference, that were both women's rights, civil rights, workers' rights, LGBT rights, working with people with disabilities, seniors, an effort to really bring everybody together to think proactively, what is it that we thought was needed to address harassment and discrimination in the workplace, and what would we put forward? And so these principles were really an effort to have a proactive, fairly broad vision of what is needed. We're not under any illusions that it's going to be enacted in whole shortly, either nationally or at the state level, but at least we could point to it as something that we thought was necessary, the kind of reforms and changes that were necessary to really address the issues of harassment in the workplace. So I look forward to this discussion and turn it back to you, Andrea.
Thank you, June. So the coalition document lays out several overarching principles that I have found very helpful in guiding me as I evaluate and negotiate policy proposals, especially given the unique context in which these policies are being advanced. By that I mean the heavily mediatized Me Too movement, which the media often portrays as focused narrowly on sexual harassment, and Hollywood and other high-level professionals. So I've found these principles in this document helpful in ensuring that we aren't advancing policies or accepting compromises that won't actually get at the problem we're seeking to address, or it will have unintended negative consequences or leave out communities that are most vulnerable to harassment. So the first principle is that our policy response should not just focus narrowly on sexual harassment, but all forms of harassment and discrimination. Many women experience harassment because of the intersection of their race and sex, or their national origin and sex, for example. And also, harassment often contains offensive comments based on multiple identities like national origin, ability, and sex. And the sexual harassment a Black woman experiences, for example, may include racial slurs and reflect racial hostility. And sexual harassment often occurs with and is further entrenched by other forms of sex-based discrimination, like pay discrimination. So if we are strengthening protections or prevention mechanisms for survivors of sexual harassment, we really need to be doing the same for race-based and other forms of harassment if we really want to address gender and racial inequality in the workplace and prevent sexual harassment. And legislation that focuses exclusively on sexual harassment would have the odd result of providing a worker who experiences multiple intersecting violations with only partial protection. And this is an important point to lead with because many of the federal and state policies introduced in response to Me Too this past session focus narrowly on just sexual harassment. But you can still use the Me Too and sexual harassment angle to message about the policy, but the most effective policies will be written to address at a minimum all forms of harassment and discrimination. The second guiding principle is related to the first. The coalition document states that we will oppose any legislative proposal that, in the guise of harassment-focused reform, attempts to roll back or undermine any existing civil right or workplace protection. And this is important because we are all well aware that in this environment, making changes to civil rights protections can be dangerous. Opening up that can be dangerous. So it's important to affirm the bedrock principle that we are not going back. Our civil rights are not on the bargaining table. And this is a time for our nation's workplaces to move forward, not back. And finally, as we all know, legal reforms must be accompanied by more resources to enforcement agencies to increase their capacity to conduct outreach, education, employer training, investigations, and enforcement actions. Otherwise, the law may be worth no more than the paper it is on. And one last principle that was a central part of the collaboration around this document with worker justice groups like Alianza de Campesinas and NDWA is that the most vulnerable and marginalized workers must be centered in our policy response and in the policy creation process. Low-wage workers and immigrant workers are vulnerable to harassment in unique ways and experience some of the highest incidents of harassment and retaliation. And so we need to make sure that our policy response doesn't just benefit those with the most privilege and financial resources, but takes into account how a worker's lack of financial resources or immigration status makes reporting harassment or bringing a claim or finding counsel even more difficult. And I'm really excited that we're going to have Alejandra Valles from the Yabasta Coalition on the webinar today to talk about the importance of worker-led policy reform. So now that we've laid out those principles, I want to turn it over to Jillian Thomas with the ACLU to discuss the specific legislative priorities.
Thanks, Andrea. Hi, everyone. Thanks so much for joining today. This is really a critical time for state legislative action. So I'm thrilled to be participating today. So as you've heard, this kind of seismic moment for all of us as advocates has led to a lot of discussion about how do we fix this problem. I mean, sexual harassment has been illegal now, according to the Supreme Court, for over 30 years, and yet it still continues in really epidemic proportions. According to how, depending on how the survey asks the question, as many as 85% of employees are still reporting that they experience harassment, and obviously some fields are more vulnerable than others. So the key question that we've come up with in thinking about legislative responses is what is causing these problems, and more importantly, how do we incentivize employers to fix the problem and prevent and address harassment when it arises. So I think the first there are sort of four major kind of thematic buckets, if you will, to the different kinds of proposals that are coming forward. The first is simply expanding the law's current protections. Federal law, Title VII of the 1964 Civil Rights Act has a 15 employee threshold, so and a lot of states follow that kind of cutoff, and so obviously smaller employers or employees who work alone, such as home health aides or domestic workers, are going to be left out of the law's protection. Similarly, folks have to be, at least under federal law, employees to qualify for protection. So that leaves out a lot of people who are increasingly making up our workforce today. So independent contractors, interns, anyone who works in the gig economy is very likely to be left out in the cold. In addition to just sort of the coverage issues that exist in the law, there are certain other barriers or limitations baked in right now, and so legislative proposals to both expand the size of the employer and the nature of the employees that are covered, and then also addressing the barriers within the law, such as statutes of limitations and other sorts of barriers like that, but we'll get into more details about that. So the first bucket is expanding workplace protections. The second is getting rid of employer-imposed secrecy. And this is just that's a fancy way of saying increasing transparency within employers. Employers engage a number of different kinds of mechanisms that keep employees from talking to one another, keep enforcement agencies from knowing about systemic abuses, and additionally, then prevent folks from sharing information with one another and seeking redress collectively. So that means dealing with, using legislative proposals that deal with problems like non-disclosure agreements. And you heard a lot about NDAs, so-called NDAs, through the Weinstein scandal. And those were sort of the most abusive use of NDAs, but there are lots of different forms. Number one can be non-disclosure agreements that are a condition of employment, meaning when an employee starts working, they sign something that says, I will not say anything bad about the company to other people at the company or outside the company. Obviously, that stops people from sharing information, and legislation outlawing those kinds of provisions really have made an appearance, and Andrea can speak more to details, but have made an appearance in a lot of legislatures this session, and we applaud that. There also are NDAs as part of settlements, and this is more complicated, and you should just be aware of this because, of course, I think all of us would believe that sunlight is the best disinfectant on this problem, prohibiting protection of serial harassers through multiple confidential settlements is on its face not something we want to be encouraging. On the flip side, those of us who work with harassment and assault survivors, and I'm sure a lot of you on the phone know this as well, don't want to have the fact that they've raised a legal claim or entered a settlement be something that follows them. Google is a powerful tool, and to have a harassment allegation follow you for the rest of your life is not something that is appealing to a lot of people. So there's been some talk of outright bans on NDAs, but we would actually suggest that it's a more nuanced issue than that, and I would urge you all to get more guidance from the folks on the call or from others in your area who work a lot in this area to, give some input about what the proposed legislation does and doesn't do. Another way that employers keep things secret is to impose arbitration agreements, forced arbitration. And we could have a whole webinar just about what's wrong with forced arbitration agreements, but the bottom line is that roughly 50% of the private sector population is covered by them. And they essentially require an employee, and frequently they're not even aware that they've signed an arbitration agreement at the start of their employment. that if they have any dispute arising out of their employment, including a discrimination claim, that they are not going to have the right to file a lawsuit, but rather that they have to go to arbitration. And arbitration is usually paid for by employers. It's not a judicial forum. It may not even have a judge presiding over the proceedings. They're not governed by rules of evidence or other rules of civil procedure. So it's an extrajudicial way of resolving complaints that is vastly tilted toward the employer rather than the employee. And also important for this topic of secrecy, they're not publicly known. The filings and the outcomes are not publicly known. So again, serial abusers are able to get away with serial abusing for many years. The one thing that we've seen is that a lot of a lot of state legislatures are trying to get rid of forced arbitration through legislation, and we would caution that that is probably one of the less attractive responses to this current moment, simply because there, as a matter of federal law, might be an issue with those laws even being able to move forward, or rather they might be voided. There are ways around it, but I would just caution that this is probably something that is better suited for federal response than state, although you will be seeing quite a lot of them, I predict. And you see here also that there are some pieces of legislation that are requiring affirmative reporting by employers, again, to alert the public, consumers, as well as government agencies to the incidents of harassment going on under their roofs, and then strengthening anti-retaliation protections. You know, statistics show that up to 75% of people who experience harassment don't ever report it, and fear of retaliation is the #1 reason that they don't, and with good reason. Unfortunately, most people who complain about harassment do experience retaliation. So strengthening those provisions through legislation, increasing the penalties that come along with them. Again, that's also part of the gap filling that some of the expanded protections would provide that I mentioned in the first bucket, if you will, in terms of increasing damages that are awarded for willful violations. Those are all ways in which we're seeing legislatures try to address the current incidents of harassment. Another and related transparency-related measure is removing barriers to access to justice, and this is very much the issue that's been mentioned about dealing with NDAs and arbitration. Those are things that keep people out of court, unable to talk to one another about vindicating their rights. But then there are also some additional kind of limitations that are baked into the current legal structure that legislatures are starting to look at, such as I mentioned, statutes of limitation. And these under federal law are 300 days since the last act of harassment. That's your deadline for bringing a federal claim. In some states, it's longer, but not necessarily. Really does vary. And so that's, again, an expiration of your ability to vindicate your legal rights, which in turn has the effect of employers not feeling as deterred in allowing harassment to flourish, because they know that they're essentially safe once a certain period of time has expired. Current law, and especially legal decisions that have interpreted the law and act as binding precedent, have made it difficult in some circumstances for victims to get redress. Because individual harassers may be doing wrong, maybe subjecting them to unlawful conditions, but then how do you impose liability on the employer? And currently, there are a number of different sort of barriers to transmitting liability to the employer, even if the harasser is a supervisor, and a startling number of cases, even involving physical harassment by supervisors, have not been found to rise to the level of being illegal conduct, and we believe that that is, definitely something that needs to be addressed. So you're going to see a lot of statutes, a lot of legislation addressing, you might hear it called automatic liability or vicarious liability for employers when a supervisor is the one doing the harassing. Similarly, under federal law, individual harassers are not held liable. And that is something, again, that a lot of states and localities have already addressed, and you're going to see it a lot more in proposals. That can sometimes cut both ways because not all harassers have necessarily the deep pockets to be able to pay a judgment, but even the threat of being able to have someone's name out there as you know, having been sued for harassment is certainly has some deterrent effect. And removing caps on damages, as I mentioned, the punishments that we have, these are for the non-lawyers on the line. I mean, these are civil penalties that are available, and so in addition to the reputational damage that can come from a lawsuit, we want employers to have to pay damages to the folks who have experienced harassment. Under federal law, there are caps now on damages depending on the size of the employer. They can range from $50,000 to $300,000. And for many of the largest employers, that's actually not going to be a deterrent. It's something that they're willing to absorb as the cost of doing business. And so we want to make sure that that is not something that they just sort of work out in an algorithm on their balance sheets as something that they're willing to take on, but rather that when there's really egregious harassment, that those caps don't limit the liability. So that's another kind of proposal that you're going to see. And then finally, we've got the buckets of increasing workplace protection so that you've got more people covered over a greater period of time. You've also got greater transparency. And then promoting prevention is the last bucket. Sorry, just before moving on, I should also mention, just in terms of one other barrier that's significant, is that the legal standard that applies to what kinds of conduct are in fact considered illegal. Under the federal standard, the phrase that gets thrown around a lot is that the harassment has to be severe or pervasive enough to trigger liability. Some states have mirrored that in their own laws and court decisions. Some have different standards, and the severe or pervasive language has really caused a lot of consternation in our community, given many of the bad decisions, like the ones I've mentioned, the category I mentioned, where physical harassment by a supervisor might not even trigger liability. And overall, only 2% of sexual harassment victims who get their cases in court that are not, they're not dismissed before trial, only 2% are successful. And the severe or pervasive standard is in large part to blame for that. And so there is some movement afoot to be reconsidering what the threshold is between merely offensive conduct and illegal conduct. So those are another kind of proposal you'll see. So now moving on to prevention. I mean, obviously what we want here is for employers to want to do the right thing and to want to do it on their own. And there are plenty of resources out there available to help them. But if they don't, or if they are concerned enough about liability that they want to actually do something more, these are legislative measures that are designed to make them want to do more and to give them the tools to do more. So mandating more regular training is the substance of a lot of proposals that have come up around the country. And just a note here about training. Training gets a bad name, and to a large extent, it's warranted, because for the simple fact that there's a lot of really terrible training out there. But the EEOC, Equal Employment Opportunity Commission, convened a task force and put out a report a couple of years ago about why harassment happens and what can be done to stop it. And I really recommend it to you, everyone on the phone. It's as government reports go, it's actually a pretty readable document, and it collects all of the social science about training and why training often doesn't work, which is mostly because it's not frequent enough and it's not detailed enough. And so there's a very good case to be made that when training is done well and done frequently, and it's part of an overall regime of prevention, that it can be very successful. Legislation also has been mandating climate surveys so that employers are essentially required to know what's going on at their under their roofs, even if they don't want to know. And also requirements that employers provide multiple reporting mechanisms. I'm sure those of you on the phone who are advocates know that frequently, your client is going to want to go to the person they work with most frequently or feel most comfortable with, even if that's not the quote-unquote right person to call in HR, or there may not even be an HR department. So what this is aimed to get at is to give employees multiple avenues to complain, not have the burden on them to seek out the right person, quote unquote, but in fact to make it easier for them to alert someone in charge that they are experiencing harassment. And then finally, eliminating the tipped minimum wage. And the link here is that the minimum wage is closely correlated with harassment. Over 60% of tipped workers are women, and over 70% of them are servers, and they experience harassment, servers in restaurants, and they experience harassment in record numbers. Over a third of the EEOC's sexual harassment complaints come from those in the restaurant industry, which is of course a tipped industry. And so the tipped minimum wage, which is only $2 and a few cents an hour, really increases increases vulnerability to harassment, because basically workers have to take it if they hope to earn a living wage. And a lot of employers, we also have heard, encourage workers to, in fact, solicit what you might call harassment in terms of how they dress, how they act, and certainly to suck it up when it happens. So those are the various ways in which we've been seeing harassment tackled in legislative measures around the country, some more effective than others, and we're happy to be providing technical support on that as the next session moves forward.
Thank you, Jillian, for laying out those legislative priorities. And I'll say that we've already seen some movement in the states around these different priorities this past session. A few examples: New York and Vermont extended protections against sexual harassment to independent contractors. Really important progress there. Washington, California, Maryland, Tennessee, and again Vermont passed laws prohibiting NDAs as a condition of employment. And New York and California tackled what Jillian was explaining, that more complicated situation of NDAs in the settlement context. New York took the approach that they banned NDAs unless the claimant requests the NDA, and built in some informed consent requirements, including a 21-day period to consider the NDA and then 7 days to revoke it after signing. So not a complete ban on NDAs, is still at the option of the survivor, something they can request. And there are some more examples out there. New Jersey has an interesting bill, it hasn't passed yet, but another model to look at is just kind of how to walk this line, making sure we aren't, but
Okay, can everyone hear us now?
I can. This is Jillian.
Okay. I understand that we got okay, out. Great. Look, it looks like everyone said that. So many apologize, everyone. Thank you for letting us know that the sound went out and that it has come back. It looks like our phone system went down, so we are now using our computer audio. Hopefully it sounds good. Thank you for your patience. We appreciate it. Okay, I'm not quite sure at what point I cut out, but I'm gonna just move forward and say that we have a resource that documents all of the different legislation that passed this past session in response to Me Too, and there has been some movement, which is very exciting, and these are all important steps, but this is not the end of the conversation. None of these policies themselves solves the problem. It's not just enough to pass an NDA bill and by doing that we solve the sexual harassment box. And not come back to the issue and work on more reforms. Nor is this the end of the conversation, because it's not just progressive states like the many we saw this session move legislation that are working on these policies. While a lot of progressive states passed them this past session, there's a lot of Me Too energy in more conservative states like Texas. So with that, I want to turn it over to Chris from the Texas Association Against Sexual Assault.
Yeah, thanks, Andrea, and thank you for inviting me to participate on this panel. I believe I was invited particularly to offer a kind of state-level snapshot of how the last year of advocacy around workplace harassment is playing out in state legislation. And as you heard from Andrea's last segment, Texas is by no means the only state that sees some legislation moving around this issue, but we might be an interesting case study, so to speak, given our historical reluctance to pass really much of any kind of business regulations at all. So I want to just hit a few main points. First, I want to talk about just why this is an issue that's important to the sexual assault policy field in general. And as part of that, kind of make a little pitch to y'all who might be working on labor policy to really engage with sexual assault advocates in your state. And then I'll tell you a little bit about what's on the horizon in our state legislature here in Texas. First of all, I do want to state plainly that labor protections and harassment protections are an issue that are deeply important to sexual assault advocates. I think a lot of people go straight to criminal justice policy when we start talking about sexual assault, but within the field, I can tell you that we really acknowledge that if we're serious about promoting health and safety, we really need to focus more broadly than criminal legal responses to violence. We know that only a fraction of sexual violence is reported to law enforcement, and even less than that is ultimately prosecuted. But at the same time, as we know, sexual trauma can destabilize really every aspect of a person's life, including the employment and all the collateral financial effects that come with that. We know that the research says about 50% of sexual assault survivors end up losing or leaving their jobs due to the assault and the associated trauma. And as folks have pointed out so far on this webinar, low-wage workers who have few employment alternatives tend to be at the highest vulnerability for workplace violence and harassment. And so if we want to advance policy in those women's interests, we know within the sexual assault field that we need to work on labor policy specifically. So connected to that, I just want to give my pitch that if you're somebody who works primarily on labor policy or harassment issues, do reach out and engage your sexual assault advocates. It's something that we're looking at actively. Your state sexual assault coalition, TASA, where I work, is Texas's coalition, can probably help you articulate these connections for policymakers and build a strong coalition. The other thing I'll say is that sexual assault coalitions are typically plugged in with direct service providers like rape crisis centers, legal aid attorneys, and others who may be able to identify certain firsthand experiences that can be helpful to illustrate the issue for policymakers. So with all that being said, let me tell you a little bit about what's going on in Texas. Over the last year or so, we have seen a heightened interest in addressing workplace harassment, although admittedly so far that has been only through legislation introduced or proposed by Democrats. That's not to say that the support ultimately will be entirely partisan, but that's where we are now. Generally in Texas, just taking a little step back to give you an idea of the legislative landscape, generally the deck is stacked against business regulation in general and heightened worker protections. This is a state that has a very strong business lobby as well as a very strong lawsuit reform lobby. So by way of illustration, every year we see legislation that's filed to protect workers, primarily in Texas's massive construction industry, from things like wage theft and workplace safety issues, and that legislation really rarely passes. At the same time, we always see legislation that's designed to weaken unions, and that regularly garners a lot of support. So I say that just to offer you a general sense of the policy climate here. But that also kind of underscores the fact that we're seeing a new interest in addressing sexual harassment in the workplace feels really meaningful. It feels like we have a real opportunity to do something that we haven't necessarily had in the past. It is too early to say how successful any particular legislation is going to be here in Texas. We have a biannual legislative session that starts in January 2019. So today is actually only the fourth day that legislators are allowed to file bills before session starts. But we do expect it will be a conversation here in a way that it just hasn't been before. And already on the fourth day of pre-filing, we've already seen several specific bills that sexual assault advocates, and TASA included, will support. Those include a bill that would expand the application of sexual harassment prohibitions to employers of all sizes, not just the Title VII size limit of 15 employees or more. There's also a bill that would put restrictions on non-disclosure agreements and mandatory arbitration, as Jillian was describing. We'll have legislation to expand unemployment insurance eligibility to workers who quit their jobs due to sexual harassment, so that they won't be deemed to have left their employment voluntarily and therefore ineligible for unemployment. And we still think it's possible, this isn't a done deal, but we still think it's possible we'll see legislation to extend the statute of limitations for sexual harassment. Any one of those may very well be a heavy lift for the authors. That's yet to be seen, but we're really excited to see it introduced. I also want to note, thinking back to Andrea's initial comments about the guiding principles, that each of the pieces of legislation that we've seen so far in Texas are still limited to sexual harassment and not harassment on the basis of other categories of identity. That's an issue that we have discussed with our allies here in Texas, and given the political climate, it has been the assessment, unfortunately, that that's just the most viable path to enactment. By the end of our session in May of 2019, we're going to find out whether that's true. But with that being said, thanks for having me here. I would be more than happy to connect with anybody afterward on any of the specific legislation or bill language, or just helping you to connect with your local sexual assault advocates on these issues. And I also want to very quickly thank our national partners who are hosting this webinar for their fantastic research and policy guidance over the last year. It's really been invaluable to us at the state level. So thanks.
Thank you so much, Chris. I'm going to turn it over to Alejandra now to speak about some of the amazing organizing that she's been working on and many workers in California have been working on in the last few years to really strengthen sexual harassment protections. Alejandra?
Hi, everyone. Thank you for having me, and thank you for all of that just amazing information for all the participants on the panel. So I am the Chief of Staff, and I'm also Secretary-Treasurer for SEIU United Service Workers West, which is the union that represents janitors across California, along with other private sector workers, subcontracted out workers in the security industry, janitorial industry, and also in the airport industry. And when Rape on the Night Shift came out in 2015, which is the PBS Frontline documentary highlighting the rapid abuse of sexual harassment, but also rape on the night shift within the janitorial industry, the first thing that our union had to do was take a look at within and ask ourselves, how many of our members are actually coming forward and talking to the union and about what's going on and filing a case or a grievance or looking to us to help them report. And the truth was that they weren't doing that. And we didn't have a bunch of cases that we were just sitting on. And so we had to start the work at really looking at ourselves. And so there's a lot of work that the union did with women in the union and internally to really launch a lot of this. But I'm not going to focus on that piece as much as I am on the work that we did with our members. And so our executive board, that is all rank and file members, said, we need to screen this documentary up and down the state of California. And so we started doing that. And they themselves wanted to do that. And from those screenings, you had a lot of women saying, I want more information. I want to get involved. What can we do? So we had a very simple, anybody that wants to get involved or wants more information on this, come to this next meeting. And that next meeting became the first of many cohorts that we call the janitor promotora model and the compadre promotora model in our union. And those cohorts were really a 6-week training of over 48 hours of gender-based violence at society at large. And then many of the women said, what if we had this in the workplace? A similar model, but in the workplace that was deep, that was frequent, but that it was led by us. And so part of what we learned in these cohorts that I think was the most important part was that guiding principle, that the answers are from within, that the culture of any industry, the workers know it, they know what the harassment looks like, how it escalates when they're in the break room, when they're in the conference room, when they're outside throwing out the trash in the trash bins, that the workers know what the problem is, and they also know what the culture is like. So in the janitorial industry, one of the major issues was that many of the women, because of a lot of cultural barriers, did not understand the difference between what constituted rape, what constituted assault, what was harassment, and what was stalking. So many of the women just did not know. One woman, for instance, had been shared in one of the cohorts that she had been violated with her own broomstick. But in her mind, she never considered that assault or rape because of her own traditional cultural norms and understanding of what traditional intercourse and what was what constituted it. And so they did not know, many of them, that harassment was not legal in the workplace. And obviously there was a difference between what was a criminal act and then the harassment that was happening in the workplace. But what we learned from all of these cohorts is that many women had actually it started with harassment and it ended up in rape. Many of these women work by themselves. They're vulnerable. They're on the night shift. And 70% of the workforce are women. And the leads and supervisors and the foremen who give out the keys, issue the keys every day and pick them up at night are men. So just the overall structure of the subcontracted work in the janitorial industry is very male dominated, and a lot of the cleaners are janitors. So, and I don't know if you're able to follow the pictures of the in the PowerPoint that we submitted, but I think the pictures also tell just a lot of the story of a lot of these women who started breaking their silence and started coming together and saying, we are willing to strike in our own contract around more enforcement and education and creating consciousness in the workplace in a different way. We do not want something in writing when we get hired saying, here's what to do to report, go to HR and this is illegal. Or we don't need just something up in our bulletin board. We need an in-person mandated training that will include a peer-to-peer component where we ourselves are helping to deliver that training because we know what the culture in our industry looks like. And so really those became our guiding principles to help fight rape on the night shift. And so then that's what guided the legislation. And that's really what has guided all of the work from the promotoras to the male cohorts that we've had with the compadres, to also the work that we have done with our current employers to get them to partner with us on changing the culture in the industry and investing in-person training that includes a peer-to-peer component where janitors and survivors themselves have helped define the curriculum and are the ones that are also helping to deliver it in the workplace. And so we were successful at the state level at winning a registry for the janitorial industry. That registry actually said, as if you want to do business in California as a janitorial employer, you have to have paid your taxes, you have to have paid any unpaid wage theft claims against any of your workers, but you also have to mandate, you also have to provide an in-person training for your entire workforce. And that was groundbreaking because many industries don't have this, and if they have something, it's not in person. It's on a video only, and it's something that you get in writing, and workers sign it and say, okay, you've been trained. And nobody walks around every day in this industry carrying around their HR policy or handbook. So we did win that, and that was a bill called AB 1978 that mandated the in-person training. And last year, we actually were incredibly successful at moving the Janitor Survivor Empowerment Act and having bipartisan support at the assembly level and also at the Senate level in California. But unfortunately, Governor Brown vetoed that bill on the last day of the session. So, and that bill would have actually mandated that in-person training has to include an a peer-to-peer component, so that the deliverers of that training and the messengers of that are the actual promotoras and also the compadres. And really what we believe there is that not that the entire training has to be done by them, but that in order to have an effective training in the workplace, the same way that we had them with the cohorts of the compadres and promotoras, that it had to be a joint approach. Everyone from the bottom up in that workplace had to say this is important and we're doing it together, so that it had to be collaborative. And so if you only have an HR manager or an employer doing it by themselves and saying, here's what to do, here's where to report, that was not going to be as meaningful and also as helpful in changing the culture as if you actually worked with and put in that time to work with your employees to have them have a real meaningful voice within changing that culture and being part of this training. So that, is the story of Ya Basta. And I would say and just really lift up that part of the number one lesson and our guiding principle to all of this work has been that the answers are from within. If we want to change workplace culture and not just check off another box of liability and compliance, then we have to work and put that time into talking and finding out what those workers need, how they see the problem, and what they think is part of the solution. But that we also have to invest in building a coalition of partners that really believes in worker-centered solutions and survivor-centered solutions that include a trauma-informed approach. Many of the women that we talked to had been living in silence for 20 years, who had been raped on the night shift. And what we learned is that having a trained promotora who was a victim advocate, who had gone through the gender-based violence training in society at large, that they were that they knew how to respond, where many supervisors have not known what to respond when somebody says and breaks their silence and says, here's what happened to me. And that how you respond, or that first response you get if you are breaking your silence, will make the difference of somebody living in silence for years and possibly decades, or actually moving forward and reporting it and helping to keep that workplace safe. So, I would say that our guiding principle that has guided our communications work, that has guided our policy work, that has guided our coalition work, that has guided our just our overall strategy of ya basta, enough is enough, is that the answers are from within, and that the collaborative approach and in-person, meaningful, substantive training that includes a peer-to-peer component is going to be what actually is needed to change the culture in the industry.
Thank you so much, Alejandra, for that really inspiring example of how we should be doing all of our work, and for those guiding principles. So I recognize that we are almost at time now, and apologize for our technical difficulties. But if you have a question, can you please put it in the question box in the system? And if you have some work that you're doing in your state that you would like to share, or a policy that you think is important to raise, you can raise your hand in the system and we will unmute you, and you should be able to talk then. So while folks are doing that, I will answer one question that came in, which is about what resources we have and can send folks to help kind of formulate policy campaigns and demands. And on this resource page here, we have a few documents. One is the one that I mentioned after I got cut off by the system, which is documenting the policies that have moved this past session around statute of limitations and non-disclosure agreements and reporting requirements. Another document is about our state playbook for gender equity. I believe I have that listed on there as well as a resource. Yes, our state playbook for gender equity, which involves a whole bunch of policies that the Law Center works on, but does have a specific legislative agenda focused on sexual harassment at school, at work, and in healthcare, and what kind of policies we need there. And then a specific resource within that, really breaking down what are the policies we need in the workplace sexual harassment space. So that, I think, can be a useful resource to kind of start formulating ideas. I see a couple of hands raised here. Sure, let's see. I'm going to call on Michelle Siri. You should be unmuted now, I think. There you go. Michelle?
Oh, sorry. Can you hear me now?
Yep.
Okay, sorry. I put my question in the question box as well. I just wanted to know, Maryland is one of the states that did a kind of a ban on disclosures, and we set it up. We did it for the as a employment requirement, but also we set it up so that if the federal level things change, that it would go into effect then as well. And I was just curious if there's any update on the movement at the federal level. Is it still something that's being contemplated, especially now, to try and change the NDAs?
I don't know, June, you have anything you want to say there, or Jillian, as our more federally focused people?
Okay, I don't know if you can still hear me because I went off the phone and now I'm on the computer.
Yep, we can hear you.
Okay. Well, there's several bills that would ban the NDAs, but it's really too early to say how it will be dealt with. I mean, now we have a situation where we have strong support within the House, but the Senate is still problematic. So we're still processing all this and figuring it out. But that's not only in the comprehensive bill that we expect to be introduced, but it's already in a bill called the Empower Act that was introduced about 5 months ago by Senator Kamala Harris and Senator Lisa Murkowski. So it is bipartisan, and there was also introduced in the House in a bipartisan way, but other than that, no action's been taken on it.
And
thank you.
I'll just add, I know a thing that many states are thinking about around forced arbitration, and this is something Jillian flagged, that there is concern about federal preemption of any efforts by states to limit or ban forced arbitration. But there are things that states can do, like that might be more likely to survive preemption, like requiring employers bidding on state contracts to disclose information regarding forced arbitration agreements, agreements that require employees to address harassment or discrimination and claims through forced arbitration. So some transparency around that could be a way to disincentivize employers from using that. I think we're going to unmute. Are there any other hands raised? Okay. Okay, yes. One person has written in, how have you all dealt with those who feel like the movement leaves men out? Of course, I pick one of the harder questions. Being asked. I don't know if any of our panelists want to speak about the inclusion of men and maybe examples that we've seen in the states or at the federal level of male legislators being involved.
Sure. This is Jillian. Alejandra.
Oh, okay. No, you go ahead, Alejandra.
Within the janitorial industry, we knew we had to incorporate men, and actually a lot of the male janitors, that this was also an issue, and that many of them were harassing. Some of them did not know that what they were doing was wrong. Others thought it was a joke, and clearly there were some that were the worst offenders. And so we knew that we had to deal with that. And so this is why we started, and we were intentional about having a compadre circle of male janitors that were going deep on this issue and what could be done. And so as part of that, it really also brought to light that, not every single man in the workplace is a rapist and also is an offender, but that we did have to have clear understanding of how in our industry, what happens is they just get recycled into another employer, and they just get hired on. And many of these employers don't do any kind of reference checks or background checks or any of that. And so they were just going to get recycled over and over again, and that the behavior was going to continue unless they were part of the solution. So the women, and that we now have a compadre circle, we have the cohorts of promotoras, and the work is in line. And that's the only way that we could continue to do that work within our union. And including now, we're even looking at how do you have an approach when there is some kind of harassment, when the victim and the survivor wants to address it with the offender. How do you ultimately get that person to understand the impact of their actions? So this whole trauma-informed approach that we've been exploring with some of our partners is key to that, but men have to be part of the solution if we really want to be able to change any kind of violence in the workplace or in society. And so the janitors have been incredibly intentional about doing that.
Thank you so much, Alejandra. And I'm going to have to actually cut things off since we're over time, and I understand actually we have an obligation to finish this right at 3. And so there are a number of questions here in the question box, and we will note those down, and we'll be sending along the PowerPoint with the resource page and contact information so you can follow up with us individually. And I really apologize that we've gone over time and have to cut it off here, but thank you all so much for joining. And we will be continuing this conversation. And thank you especially to our speakers.